Hello. I am an ICE 50 avatar and have been given consent from the real attorney Robert L. Shapiro to present his following article for you. Robert L. Shapiro. During a high-profile or controversial criminal case, emotions can often run as high outside the courtroom as they do inside, as television pundits, victims' family members, friends of the judge, and attorneys, and average citizens all join the heated discussion concerning the intricacies and frustrations of the ongoing legal proceeding. A frequent focus of debate is the role of the defense attorney, and the questions come in a variety of ways. When questions are posed to me, my answers usually depend on who is asking and why. If a query comes from a friend or a family member, it often carries with it a mix of curiosity and genuine concern, and the operative word is how. How do I do my work? How do I meet the challenges? How, quite literally, do I mount a defense case? I can easily explain to my sons or my friends, for example, how a lawyer might put a defense together for a client. Part textbook, part personal experience. My response can lay out the hypothetical circumstances and the details, the rule of law and legal procedures, the roles of the court, the police, the prosecution, and, if it comes to a trial, the jury that will lead, ideally, to the appropriate resolution of a case. But when the question comes from a citizen on the street, it inevitably comes as a challenge, carrying with it the implication that defending someone accused of wrongdoing is not a task for the righteous. In that instance, my answer comes not from a textbook or my own case experience, but from my passionate belief that what I do is not only righteous, but ordained by and within my country's history. We live in a nation founded on the principles of freedom and liberty. We fought and paid dearly for these principles. Robert L. Shapiro has practiced criminal law since 1967. First as a deputy district attorney for the county of Los Angeles, then in private practice specializing in criminal defense. He is now a partner in the Los Angeles law firm Christensen, White, Miller, Fink, Jacobs, Glazer and Shapiro, LLP, and author of The Search for Justice, Warner Books 1996. 106 Loyola of Los Angeles LAW Review. Cause a democracy is a fluid thing, subject to the will and might of its people. We continue to pay the price today. The American Constitution, and in particular, the 10 amendments that make up the Bill of Rights, is where that price is clearly set out, in plain and simple English. The founders, painfully aware of the injustices suffered by individuals at the hands of the Tudor-Stuart monarchies, left little to chance. Of those first 10 amendments, half are specific to the rights of citizens who find themselves in an adversarial relationship with the state and its judicial system. The Fourth Amendment is the safeguard against unreasonable search and seizure. The Fifth Amendment sets out the protections of due process, including the right against self-incrimination. The Sixth Amendment ensures a public trial and the assistance of counsel. The Seventh Amendment guarantees the right to a jury trial. The Eighth Amendment prohibits cruel and unusual punishment. It is the provisions in this document and nothing else, not good intentions, not patriotism, not capitalism, not orthodoxy, that stand like a sentry between us and our becoming a police state. The Bill of Rights and an attorney's rules of professional conduct require they do not suggest that anyone accused of a crime is entitled to a lawyer. Defense attorneys are not allowed to adjust their efforts to fit the circumstances, no matter the crime. No matter how morally questionable the person accused of it may be, no matter the public or private assumptions of that person's guilt or innocence. Surgeons do not do less than their best when confronted with a person they detest on the operating table. Neither do lawyers. They cannot. Their respective professional codes of ethics expressly forbid it. 1 Prosecution attorneys and defense attorneys are officers of the court, both bound by the same rules of evidence and the same rules of professional conduct, but our advocacy roles are different. The prosecutor's responsibility, according to the American Bar Association's Model Code of Professional Responsibility, is to seek justice, not merely to convict. The defense attorney's responsibility is to represent an accused individual's interests when the formidable resources of the state are arrayed against that person, to represent his client zealously within the bounds of the number 1 Model Code of Professional Responsibility. Number 2. The resulting adversarial presentation, says the Model Code, counters the natural human tendency to judge too swiftly in terms of the familiar that which is not yet fully known. But justice means different things to different people. And when most people talk about justice, they're talking about moral justice. Did someone commit a crime against the people? If so, that person should be tried, convicted, and appropriately punished. If not, he or she should be acquitted. As a human being, I am not omniscient, and I have no better way of judging guilt or innocence than anyone else. As a defense attorney, however, I must view justice as our country's system of legal justice, which is based not on the assumption of guilt but on the presumption of innocence. Guilt must be proven by the prosecution. It must be proven beyond a reasonable doubt and to a near certainty, within the rules of constitutional law. Reasonable doubt is the standard of common sense at the heart of our system of justice. Judges have grappled with the complexities of the jury instruction on reasonable doubt since the beginning of that system. If there is doubt, there is no right to convict. In fact, there is an explicit imperative to acquit, no matter the burdensome weight of the evidence that coexists with the doubt. Judge William Blackstone anticipated society's struggle with this when he said, more than 200 years ago, "It is better that 10 guilty people escape, than that one innocent suffer." When society is confronted with the virulence of modern crime, however, Judge Blackstone's caution can seem like a musty anachronism. Not so long ago, a United States Attorney General even suggested that if a person was arrested under suspicion of committing a crime, in all likelihood he was guilty.